Hi, everyone. I'm Rebecca Smith from the National Employment Law Project, and I want to welcome you to our webinar on fighting Proposition 22 in California and fighting as well gig company carve-outs across the country. I'm just going to give you a little bit of the order of presentation and our guidelines for questions and such. We will be recording the webinar, so just so you know that. I will be giving a quick introduction, and that'll be followed by two short presentations, first from Ray Fuentes from the Partnership for Working Families, who will tell us all that we need to know about Prop 22. And then from my colleague Brian Chen at the National Employment Law Project, who will talk about both defensive and affirmative campaigns that we can undertake. And then we'll hear from you. We want to hear what folks are thinking about for the end of the year and for the beginning of 2021 in your cities and states. And we want to tell you also about how you can get involved in the California campaign. We'll have some questions in between each of the short presentations. And if you have a question, you should use the Q&A button that you'll see at the bottom of your screen. And each presenter will then take questions at that time, and we'll do more discussion and more questioning at the end. You'll be muted through most of the presentation, but at the end we will unmute you so that folks can have some oral questions and we can answer those as best as we can. So thanks so much. These are your two organizations that are sponsoring the webinar today: the Partnership for Working Families, where Ray works, and of course the National Employment Law Project, where Brian and I work. So to begin, we wanted to have this webinar because we're seeing what's happening in California with Prop 22, and Ray's going to talk more about that, but also the implications for the rest of the country. So we know that California is, and has been for a couple of years now, the center of the spotlight around, or excuse me, I want to go this way, around contracted work. But that contracted work has also been the center, or one of the centers anyway, and one focus of national debate. So we have Joe Biden weighing in, asking Californians to vote no on Proposition 22 in California, the gig companies initiative for a carve-out. We have his policy shop saying that he'll work with Congress to actually enact the ABC test around the country. And then we have folks like Elizabeth Warren and Kamala Harris also weighing in favor of an ABC test and against Prop 22. At the same time, we're concerned about what happens after California. Win or lose, we think we're going to see initiatives, and when I say initiative, I mean ballot initiatives, but probably more likely legislation around the country in different states that looks an awful lot like Prop 22. The companies are running scared right now. We think the tide is turning and policymakers are starting to understand how exploitative these jobs are. And so the companies are doing what they always do. They're throwing money at another last-ditch effort to get out from under labor laws. Folks may have seen this op-ed in the New York Times from the CEO of Uber. And I just want to draw your attention to not his proposals for a benefits fund so much, but the bold type here about, had that proposal been the law in over 50 states, workers would have had a very small amount of money, frankly, to go towards benefits to pay for on their own. This op-ed got our friends in Colorado, some of whom are on the call, pretty excited because he calls out Colorado. But we know that the companies have been active in Illinois and in Michigan and in states across the country. So we're going to talk a little bit about what we can expect and what you might expect going forward. Now I'll turn it over to Ray so that he can talk to us about what exactly is in Prop 22.
Hi, everybody. I really did enjoy that op-ed because the Uber CEO suggested that the workers would get health benefits or paid leave. I mean, not both. Why would he offer both? So I guess I'm exposing my bias. But again, my name is Ray Fuentes. I'm an attorney at the Partnership for Working Families and work with Becky and Brian on a lot of research related to Prop 22. We're really excited to share. I mean, not excited. I mean, we're concerned, obviously, but very happy to have so many of you here to share why we think Proposition 22 is so challenging and why it is so dire and important for so many of us who care about workers' rights to really pay attention to what's happening in California. Before I jump into Prop 22, I'd like to give a little bit of background for those who are not in California to kind of get a sense of the trajectory, because ABC tests, like Rebecca and Brian have mentioned and have themselves studied, really happen statutorily. They come by way of the legislature taking action. But in California, it was a little different. It started with a case called Dynamex, which really laid out a standard in California for the application of the ABC test. And at that time, it was really narrowly tailored to the state's wage orders, which really covered minimum wages and meal and rest break, and not all of the employee protective laws in California. And the Dynamex case really construed the suffer or permit standard, this broad definition of who is a covered employee for the purposes of California's wage laws, and suggested that you couldn't just have that standard alone because everybody would then be an employee. And so the way to actually constrict the suffer or permit standard was to use something like the ABC test, where it gives the protections to as many of the workers as possible, but not all workers in California become employees. The critical part of the test, as many of you are aware, is the B prong, at least for these companies like Uber, Lyft, DoorDash, Instacart. The test is essentially, do those workers do work that is within the usual course of your business? And for many of these companies, it clearly is. And the state legislature took then steps, as many people are aware, in 2019 and again this year with AB 5 and AB 2257, to really take the holding in Dynamex and extend it to the rest of the California Labor Code. It then includes all of the expense reimbursements, unemployment insurance, workers' compensation, paid leave. So it really was a pretty dynamic move by the state legislature. And as we've seen, as time has progressed, the companies who have resisted this measure have lost this legislative battle. They've lost before the courts. They're losing before regulators. And now they're being sued by the Attorney General in California, along with three of the city attorneys from the largest cities in California. So the tide is shifting. But what has pushed this even further is this Proposition 22 campaign. Really what we're describing is a well-funded but 11th hour attempt to achieve permanent deregulation for these companies, almost wall to wall. And you can see here, we don't have to go through the numbers, but they're putting up $181 million to do it. And as we've described to folks, this will be, if they end up spending all of this money, the most expensive ballot initiative in US history. And so I don't think it's really something that we think could be swept away. It's definitely a risk for workers generally, but as a model for what the future of these challenges will look like in industries far outside of the app-based industry. So that's why we really want to dig into some of the detail. And so what I would do is just provide some of that detail here. And like Rebecca mentioned, please do throw any Q&As you have. If we can't get to them at the end, because this will be a lot of content, please, we can jump at the end or try and answer them throughout. But really, when we think about Proposition 22 and what it means for workers' rights, it really falls into two buckets. What is not being provided by Proposition 22 and what would be provided under current law. And all of the things, the arguments that companies are making around how beneficial Proposition 22 is and how those really is misdirection or not I don't want to say lies, but outright falsehoods by the PR spin being designed to support this ballot initiative. So in the next slide, you see here, in the midst of, this ballot proposition was written before the COVID-19 pandemic. It was written before this country has really come, since the death of George Floyd, to really recognize and grapple in a more public way around this nation's history with race. And what we see is that the ballot initiative does not reflect those changes, nor can it, because the ballot initiative can't be changed before November. But what is missing from the ballot initiative, we all believe, is quite glaring. Not a single day of paid sick leave, no paid family leave protections, no guarantee for personal protective equipment. And in fact, companies have been selling personal protective equipment to workers rather than providing it or reimbursing workers. No unemployment compensation, no overtime premiums. And really, this is just the tip of the iceberg for the ballot proposition. But we know it's key. These are key bedrock protections, and it really is something that is not, I think, ever going to be provided to workers, and I'll tell you why in just a moment. But as well, we understand this ballot proposition is one that doesn't support the actual workers who do the majority of labor on these apps. 78% in a recent survey of ride-hail and delivery drivers in the San Francisco Bay Area indicated, and this has been confirmed by other surveys as well, not just surveys out of the Bay Area, but that a vast majority are people of color, and a majority on these platforms are immigrants. The companies know this. They know who their workforce, how their workforce is assembled. But instead, in their ballot proposition, there's no protection for discrimination based on immigration status, or discrimination for if the employer were to discriminate based on traits historically associated with race. That's a new protection in California, not offered by the ballot proposition. And there's no liability for third-party discrimination on the app, so the companies are off the hook when discrimination occurs on their platforms. So this we think is should be enough for everybody to know that this is not a good deal for workers, but is also a model for how you then try and spin this to say that it's worker protective, because on the next slide we'll show you there are some claims the ballot proposition is making, and they've been able to convince some people that this is a worthy middle ground, a way to negotiate over workers' rights. So they're offering a historic wage guarantee, they argue, 120% of the minimum wage plus 30 cents per mile. In fact, they only compensate workers for engaged time. So they know their drivers on these platforms work, they really, half of the time they spend can be uncompensated because they spend it waiting. They're only going to pay drivers for the time spent once they've received a request and when they finish it. So this means, this guarantees, because of the low reimbursement rate for expenses and this minimum wage guarantee, that they're actually guaranteeing a sub-minimum wage. They claim to offer healthcare premiums, but again, they peg it to that engaged time calculation. So they say that if you work 25 hours, you'll get 100% of your healthcare premiums paid. They don't mention that it's only for engaged time, so you'll basically have to work 40 hours a week to receive the benefit, but that it's based on the average of a low-cost healthcare premium, not your actual premiums. And they claim to be arguing for and protecting flexibility and freedom. But again, this is clearly an attempt to deregulate the industries in which these companies operate. And there's no law against providing a flexible work arrangement for workers while protecting their basic labor rights. And the reason this is also bad, everything we just described is terrible, but when you actually look then back just a few inches deeper into the substance, on this next slide, you'll see this is what makes it a permanent deregulatory attempt by these companies. And I see a question about workers' compensation not covered under the ballot initiative in a way it would be covered under state law. So the ballot initiative covers workers' compensation benefits for up to 2 years, but for serious injuries, and there is a workers' compensation benefit. But under current law, seriously injured workers would be offered a lifetime benefit. The other thing that it does that I think is pretty challenging is that it would eliminate no fault. It essentially eliminates this no fault protection that's available under the workers' compensation regime. So they can actually deny claims for workers who are engaged in some version of personal activity while working on the app. So we think that's pretty dangerous. So I saw that question for Sia, so I wanted to answer it right away. But here on this slide, this is why we know that it is a dangerous proposition for workers. There can be no amendment to Proposition 22 without a 7/8 majority of the state legislature agreeing to a roll call vote before considering the amendment. So essentially, this means no amendments will ever be considered. So nothing about this initiative will get changed. The second is that it preempts almost all local innovation and policymaking as it relates to these workers. No protections for local paid sick leave, local minimum wages, but as well as many things advocates have argued for, like access to protections against arbitrary deactivation, for example, that would be preempted. And kills a lot of different benefits that are available from local governments, like Healthy San Francisco, for example, which could never apply to these workers if Proposition 22 passes. So this is why we would describe it, again, as a wall-to-wall deregulation for these companies at a time when the workers need the most more protections than they currently are provided. And so this is why we want to draw folks' attention, even if you're not in California, to Proposition 22, why it's so dangerous. I mean, if you're in California or know people, we encourage you to help them get involved in this fight. But as Becky and Brian will mention as a follow-up, there is a significant amount of work being done to really anticipate where this fight will go next. And we know, scores of 26 states, I think, have ballot initiative processes that could allow a version of this. And we know in industries like nursing, construction, that already happen. Many of these workers are dispatched by app, but what happens if that becomes the norm and these types of initiatives become what we're fighting against? So we don't want California to be the leader of this new trend. So that's why we're fighting back and definitely want to share it today. But like I said, if there were any questions, I mean, we can also, if something comes up, we can take them at the end. But happy, because this was a lot of content, we wanted to give people a chance to ask their questions now. By chat, and we'll open up the audio at the end, or the Q&A tab. Okay, answer everybody's questions. I love it. But I'll pass it over to Brian, who can talk about a little bit more about the national perspective of some of this work.
Yeah, absolutely. Thanks, Ray. And hey, everyone. So we wanted to talk about how we can actually fight back, not just Proposition 22 in California, but in this moment when we know the gig companies are really gearing up, how do we advance the rights of contract workers generally in all the 50 states across the country? And we want to offer just a few ideas just as a starting point. So the first strategy that we think is critical is really beating back these company initiatives. Get organized to fight back against these initiatives. As Becky mentioned, we know that whatever happens with Proposition 22, the companies will be eager to keep pushing their own half measures at the federal level as well as the state level. The companies are nothing if not opportunistic. They will use any moment they can to advance their agenda. And here's one example. So when COVID hit in the beginning, early in March, Uber CEO started to push for a third way classification for gig workers. He sent a letter to Trump. He started to meet privately with members of Congress, both Democrat and Republican, talking about how a so-called third way classification would offer such clarity and modernity to our outdated labor laws. And just a few weeks later, many labor groups, including some on this webinar, pushed back. And we got organized and we published a letter, sent it to all the leadership of Congress, explaining exactly why a third way is so dangerous and that it doesn't actually solve for the problems of misclassification. It might actually worsen the problems of misclassification. The gig companies are very skilled at misinformation, at convincing legislators that their proposals will help workers. And so we think it's really important that everyone is nimble and organized and able to push back against that, being clear that these kinds of company-defined proposals like Proposition 22, like a federal third way classification, is only going to hurt app-based workers. The next strategy that we think is important is rolling back or undoing a lot of state laws that have carved TNC drivers and gig workers out of employee status. A lot of states have these laws, they've had these laws on the books that categorically exclude workers from receiving any employee benefit, such as UI. The gig companies like Uber and Handy have, over the last few years, lobbied really hard to get these laws passed. When a state has one of these laws on the books, even if you have something that's pretty advantageous, something like an ABC test for purposes of unemployment, a TNC driver, let's say, would be categorically excluded from being considered an employee, therefore ineligible to get that UI compensation. And so the map that you're looking at here shows states in red. Those are states that we think have laws that are very strict, that very strictly exclude TNC drivers, Uber and Lyft drivers. The states in yellow have laws that have a bit weaker language, we think, but still it would be an uphill battle to show that a TNC driver is an employee. Either way, you know, we believe that an important strategy is to fight against these carve-outs. Really explain to legislators why these laws are so harmful, why they need to be repealed, explain how they are preventing workers from establishing themselves as employees. And on the next slide, we'll show an even broader set of carve-outs. These are so-called marketplace platform laws that exclude anyone who receives work through a platform. So this is broader than just Uber and Lyft and the TNC drivers. This is anyone who gets work through a marketplace platform cannot be considered an employee, period. And below is the map of states with a marketplace platform law. That if you receive work through a platform, you are considered an independent contractor. That's it. Again, we think rolling back these carve-outs is really critical in the fight back to advance the rights of contract workers. Next is boosting local protections. So without even getting into the classification fight, ensure that independent contractors can access better protections now at the local level. So one thing we've seen is so-called COVID-19 or essential worker packages that have really boosted protections for the moment that we're in right now. Earlier this summer, advocates in Seattle, like Working Washington and Teamsters, have really led the way to win premium pay for food delivery workers and to win paid sick leave for TNC and delivery workers. What's actually exciting is that just last week, Philadelphia extended, they passed a paid sick leave bill that would cover app-based workers. And it also happens to use an ABC test in the legislative text so that it's actually quite broad coverage over who would receive paid sick leave. The next is minimum pay standards. This is something that has been done before. New York City was the first in the nation to do it for TNC drivers in 2018. And actually just earlier today, Seattle City Council was discussing how to implement a kind of minimum pay standard. Essentially that, you know, for TNC drivers and or for food delivery workers, that even if they are not an employee and they're therefore ineligible for minimum wage laws, they can actually earn a certain minimum pay as a contractor. And one other protection we want to talk about is deactivation centers. So setting up a local system, advocating for a local system where companies can't just deactivate the drivers unilaterally. There actually is a local entity that will help to resolve disputes around unwarranted deactivations. And it would happen before a neutral arbitrator. Drivers would get free representation. These are just some things that we think are really important on the local level. And I'll just say a note here, as Ray was talking about, one of the things that Proposition 22 does that is so harmful is that it preempts these kinds of local innovations, these kinds of local actions that municipalities can take to increase protections. And it's so dangerous because, as you can see here, there is so much important work that can be done at the local level to boost protections. And so one of the things that we are so concerned about in Proposition 22 specifically, and what we fear in legislation to come, is that the companies are going to be so eager to find ways to preempt this kind of local legislation. And so moving on to state protections for contract workers. So first is really revitalizing our unemployment programs, making sure that app-based workers, if they are out of work, can actually receive unemployment compensation, state unemployment compensation. One part of this is calling for audits to assess the gig companies on their back taxes. So in 2019, before COVID, the state of New Jersey assessed Uber's unemployment tax bill at some $650 million, just to give you a sense of how much money is not being collected by the states. And so we think it's important to have these kinds of systematic audits to really get a picture of how much these companies are not paying their fair share. And of course, there's actually bringing litigation, suing for workers to receive unemployment. And I'll highlight a recent case where the Pennsylvania Supreme Court affirmed that an Uber driver is an employee, even under Pennsylvania's right to control test. And that Lohman decision really had great language around the ways that gig companies control their workers in ways that, at least in Pennsylvania, is clear that an Uber driver, TNC drivers, should be considered employees. Next is misclassification task forces. In the last decade, more than half the states have had some kind of interagency task force focused on independent contractor misclassification. These can be really important tools to fight misclassification. And one way to boost state protections is to either advocate to establish a task force if your state doesn't have one, or push to ensure that the task force that is on the books is actually doing its job. And these task forces should have a broad mandate with participation by state agencies. They should be able to investigate, do targeted enforcement, conduct research, audit, report their findings, educate the public on the dangers of misclassification, do know your rights for workers. I mean, there's really no, the idea here is to be quite broad in what a task force can do around this issue. And finally, just one more thing that I'll say on the state level is legislation to boost misclassification penalties. Just last year, there were 2 new laws that were passed in New Jersey and Virginia that assesses new penalties for companies who intentionally misclassify their workers. So in New Jersey, that penalty would range from $250 to $1,000 per misclassified employee. And Virginia, it would range from $1,000 up to $5,000 per misclassified employee. So when you consider how widespread misclassification is, especially in the app-based economy, these penalties really start to add up. And even to a mega wealthy corporation like Uber or Lyft, these penalties can act as really important deterrents. Finally, there is the ABC test, which Ray explained, and I'm sure most people here are familiar with. I'll just give a brief recap on some of the noteworthy enforcement actions that have happened under the ABC test in the last few months. So the San Diego District Attorney sued Instacart. The San Francisco District Attorney sued DoorDash. The California Attorney General is currently suing Uber and Lyft. And the Massachusetts Attorney General is doing the same. And what's notable is that these actions, in a lot of ways, are possible because the states have an employment test that doesn't give the gig companies so much leeway. And we believe that these kinds of ABC test campaigns are hugely important. I will say that in talking to a lot of organizing groups, that there are defensible reasons not to do an ABC test campaign. Maybe the legislature isn't quite there yet. Maybe the organizing isn't there right. There might be many reasons it may not be politically right to go for it. But for all those very sensible reasons not to go for an ABC test, the one good reason is that it does address the problem of misclassification rather than providing protections around the problem. And so we continue to believe that you don't have to wait for a court case like Dynamics in California, consider bringing a legislative campaign to fight for an ABC test for employee status. And that's why there's been campaigns in New York, in New Jersey, Illinois, Minnesota, and others that really are focusing on bringing that employment test to their own state laws. And I will open up to questions on any of these. I'm seeing one from Andrew. Is there a source for this TNC carve-out map? It is from a NELP report. That might be a bit outdated at this point, but Becky and I have been working on a more recent updated version. So we'll get that updated, and when we send out these slides, we can have that updated map.
I see a question here, one about gig economy worker organizing. Should I take that now or should we jump at the end?
Yeah, go for it, Ray. I mean, yeah, please.
Yeah, I think, and this relates to another question that was answered that I answered in the chat. I mean, specifically around ways we can help protect organizing, and one of those ways is to defeat Proposition 22. It contains in the proposition, and this is something that wasn't, again, this is almost like an onion. You peel it back and it gets worse and worse. It would subject any legislation the state legislature would consider authorize bargaining on behalf of these workers to be subject to the same 7/8 majority standard. So essentially making it impossible for the state to authorize collective bargaining for these workers. And as many people on the call know, these workers, at least under this current NLRB, are exempted from federal labor organizing protections. But that doesn't mean the organizing stops. I mean, I'm involved and have worked closely with Gig Workers Rising, which is a project, a working partnership, which helps to organize with these workers and facilitate their organizing. But there are organizing efforts throughout California doing just that. And I know we're not going, nobody has an extra $180 million lying around, but what they do have are the workers' voices, and we have a pretty militant set of workers who are really bent on making sure that people are aware of what so I just look at that, but the challenges will have to come as well in a world where we, if we do lose Prop 22, we have to continue fighting against the proposition and continue organizing.
So Ray, we can go on to your next slide if you'd like.
There was a question about what the ABC test stands for. Maybe Brian, you want to answer that?
Yeah, I mean, it's the letters ABC don't stand for anything, but there are 3 prongs of this employment test. And so there's the A and the B and the C are really referring to those 3 prongs. And why we like it so much, why we think the ABC test is quite good, is that it is distilled into these 3 prongs, the A prong, B prong, and C prong. And we think that is a really effective, broad coverage to clarify who is an employee and who's not, who's actually an independent contractor.
Yeah, and I mean, as we're talking about ways to fight Prop 22, I see a couple questions here. So Rosia's question specifically, would Proposition 22 impact all gig company workers? So not all gig workers. Prop 22 specifically applies to transportation network and delivery network companies. So the TNCs and DNCs that do this work, like Instacart, DoorDash, Postmates, Uber Eats. I mean, the set of app-based facilitated companies that do work to transport people or packages. So any application that could extend to that is specifically something that we'd want to, that is covered by Proposition 22. So I think it is a good question to identify the universe, and it is seemingly narrow, but a lot of companies that do work now could fit into one of those definitions. And I think to Angela's point, I think if folks see your questions in the Q&A, I think it's right for us to think about what those post-election challenges might look like. And there are a number in the works. I mean, I can't speak to the specific legal strategies on our webinar today, but it's definitely something to keep the conversation going with allies in California. Because I think there are ways to challenge the ballot initiative after the election, but I don't think it is quite right to suggest that the AB5 fight is something that brought us to this point, because we know that workers were being defined as employees under prior law, but in a haphazard way. This is a clear standard that the state can enforce, and that the state has authorized public officials to go out and enforce, which gets us beyond, the arbitration barriers that the companies put in place. So I think that the fight was still worth having. It is still ongoing. I mean, we're engaged with the Attorney General's lawsuit on that issue specifically. But I think those conversations about what the post-ballot looks like, the post-election challenges might look like, is an important one to have. But I think that's why we're focused on defeating Proposition 22 before we get to that point. But that's what leads me perfectly into ways to join this fight against Prop 22. And the easiest first steps are obviously joining and endorsing the campaign. If you have affiliate organizations or allies in California, going to the no on caprop22.com website and listing your organization as an endorser, continually getting updates about next steps in the campaign, and different ways to plug in would be a way to step out on this issue. The other is to share some of the research. I think I answered this in one of the Q&As, so if you see an answer to questions about polling, but I'll reiterate it here. 46% of voters who have AB5 described to them think that it should be applied to ensure that employee protections are extended to Uber and Lyft drivers. The public, once they have AB5 described to them, support it. They support its application to ensure benefits are extended to workers. What the challenge is interpreting that through the ballot initiative process, and overcoming, I think, the misdirection by the campaigns. And so that's why we put together research like the Rigging the Gig report that Becky, Brian, and myself put together. So please share that broadly within your networks. We appreciate that. And then engage with other allies who can come onto this fight and do exactly what we're encouraging you to do today, but what others could do alongside you. And I think these are the easiest first steps to engage. And if you go any further, donating to the campaign, ensuring that it has the resources to win. I know, again, nobody is going to have $181 million available, but I think with strategic messaging that the campaign is moving forward on, we can really cut through some of that chatter. And once people realize that it's some of the richest corporations in the world putting up $181 million, they can discount it. And the thing I like to say to a lot of folks, if money was the only determinant of victory, Mike Bloomberg would be our Democratic presidential nominee, but he's not. And so I think it's important to recognize that once people understand where the money is coming from, what it's being used for, I think it will neutralize a lot of the messaging. And so that's part of our job. And I'll pass it next to
yeah. Thanks, everyone. And we will have some time for other questions and discussion in just a few minutes. But one reason we wanted to have this webinar is that we wanted to hear from folks about what you expect to be working on in your state in 2021 after we defeat Proposition 22. And so I'm going to give you a few minutes to just fill out this poll for us. It will help us determine what strategies we undertake as well in 2021. And we'll give folks another 30 seconds or so before we close the poll. Okay, thanks everyone. And actually, Nicole, let's leave it open for a little bit in case folks want to think about this as also we're starting a discussion. So we have a couple of questions for you, but want to hear your questions and your suggestions as well. You know, what support would be most useful to you in your campaign as we move into the end of 2020 and the beginning of 2021? What other questions do you have for us? And Ray, I think you're going to manage the Q&A here. And what we'll do is have people write their questions, but we will have people raise their hands, sorry, and we'll unmute you as we call on you for your question. I got that right? Okay, thanks, Ray.
Maybe perhaps Bukola, I'm not seeing the unmute button on my side. Maybe I'm not a host, but if you can see folks who raise their hand, I don't seem to have that ability right now. Forgive me.
Sure, I'll manage that.
Okay.
So it looks like Kirsten, is that right? Had her hand raised?
Yep.
She's unmuted.
Am I unmuted now?
Yep.
Okay. Hi, this is Kirsten representing the Colorado AFL-CIO. I was just wondering about these funds that they keep talking about where they say they're flexible funds for benefits. So essentially it's like a slush fund, and it almost looks like a multi-employer plan, like a Taft-Hartley type of fund. But of course, there's no minimum standards on providing, you know, what kind of actual health insurance, and they're not negotiating on health insurance or paid sick leave or UI or workers' compensation. So here in Colorado, independent contractors can buy into workers' compensation. And so it feels like, again, it's a very smart move on their part, but I'm just curious on how you've been able to combat that message in terms of like, it's free choice, we're giving people opportunity, we're just giving them money, and then they can do whatever they want to with it.
Well,
Who'd like to take that?
yeah, I can jump in with an initial response just from the workers' perspective, because I think the messaging is about what, you know, I think part of your question is about how are workers responding to this fund. And I think a lot of folks, you know, after they read the Uber CEO's op-ed, I think they correctly had that point. I mean, that's why I said what I said when I said, you know, it's an either or proposition, because the companies are clearly attempting to limit, you know, what they're providing. And it fits within the flexibility approach that you can work for any company and still have these benefits. They'll follow you job by job. But once we describe what is provided under current law, workers recognize that what they're being sold is essentially a bill of goods. So from the workers' perspective, I think the messaging is quite easy as long as you're describing accurately what's available to the public. I mean, I leave that to others that may have some better insight there. But I know from the driver's perspective that we've organized with, it's a pretty easy thing to talk about and to describe, and I think they immediately grasp why it's not a good deal for them.
Mm-hmm. And I think for a lot of the benefits that they say they're offering, they are intending them to take the place of social insurance, but they are not insurance. So having your employer give you $1 for paid family leave is not the same as having your employer pay $1 into a state-funded paid family leave program where you actually get real benefits for yourself and your family. Brian, anyone else want to respond? Before we go to the next question, I also noticed that someone asked if there's a one-page fact sheet on Prop 22, and Ray wrote a great top 10 reasons piece that we can share with folks afterwards.
I will throw it into the chat, actually, the link right now. And I think, is it Esther Funny? I think raised.
Yes, I wanted to ask, You know, the major concern for workers that we keep on running against the drivers, because I'm an Uber and Lyft driver, is flexibility. And I'm afraid that I'm in California, and I'm afraid that damage that's being caused because Uber is able to spend $180 billion, under $180 million, and we only have 12 million. So that means when people are going to vote in November, most people don't know, you know, because Uber and Lyft are able to get their message across. I mean, we have phone banks and all that kind of stuff. We're doing what we can, the workers, but we need money. And there's no way to go around that because we need to get the message that flexibility has, AB 5 has nothing to do with flexibility. We need to get the message out that, you know, when Uber announces, well, you know, we'll take care of you, we're going to, all these fake compensation packages, like, and it only applies, because most people are not clear, that it only applies when you are engaged. So that means if you get, let's say 15, 20 an hour, right? That would be the number that we will guarantee you that we think that workers should be compensated as well, that they should be taken care of. But people don't understand, the public and some drivers don't understand that it's only when you're engaged. So that means 3/4 of the time, I mean, I think the average is like maybe 40% of the time, we're not engaged in any given hour. So that means that you have, let's say you have one ride, a short ride, where you're getting paid $2.62. Maybe that whole ride took you 15 minutes. So that means you're only getting paid $4. Do you know what I mean? So you didn't work an hour. But we need to explain that to people.
Exactly.
And we don't have the money.
Well, I'd say a couple points. I mean, I just added the fact sheet, the quick fact sheet to the chat here. You know, to share that far and wide. That's exactly the point that we are making, and that we can make again and again. And we've expressed that in every interview we've ever done and all the research we put together. But I think the other component, I mean, this is not a fundraising call, but you know, resources will be critical, and it's important if any organizations are connected to the campaign to you know, really you know, step into that role, but also anybody on this call connected to somebody who could support the campaign. That's as part of the effort. But I think the other point is we have the messages, we have the tools and the information, but I think a part of our challenge will also be ensuring that people understand how that money is being spent and what it's being spent for. Because I think that can also help neutralize some of the spending disadvantage. So I think that's conceptually how it's supported, but again, you know, all more resources, the better, and that's what we would encourage as well. And I think I saw Zach was next in line.
Looks like Zach might be messing with his mute button. If you're there, Zach.
Maybe we can come back to him. I know that Ian Perry.
Hello.
Hi,
Hey, I had a question about how people felt about the deal that was reached in New York, which didn't necessarily bring employee status, but did guarantee better pay, and just kind of how people felt about weighing some of those trade-offs. Thanks.
And you're talking about the minimum pay standard that the city set a few years back?
Yep.
Yeah, I mean, I think that's the kind of protection that we're definitely in support of. I mean, it's always a question of what are you giving up? And in that case, the drivers never gave up or foreclosed the ability to fight for employee status. Whereas in a lot of the things that we're describing, such as in Proposition 22, or a lot of the half measures that the companies are concocting, it very much would grant some benefits while foreclosing the whole host of things that we really feel strongly that drivers are entitled to. But something like the minimum pay standards, you know, I think that's emblematic of the kind of things that is a really important local protection that if you can't quite fight the misclassification fight right now, for whatever reason, we're all in favor of boosting pay for drivers, so long as you aren't foreclosing any opportunity in the future to actually fight for what you really want to go after. And
I don't know if Zach's mic is open. Zakowski.
Zach, it looks like you're on mute, but I think we've unmuted you. Not sure what's happening. Maybe we could ask you to put your question in the chat or in the Q&A and we can answer it live.
it looks like Zach just signed out. So does anyone have any final questions? We have about a 5 minutes remaining.
Esther Funny?
What I was wondering, has anyone gone to private donors? Because I'm sure with NELP, such an organization, surely somebody knows, you know, Tim Cook of Google, because Google just sued Uber for something. So they might have an axe to grind. Or Bill Gates or Warren Buffett. Because I don't know these people. But somebody's got to know these people, and they're known for backing liberal causes. And they're known for putting $100 million for education or some cause. Has anyone tried officially to do that?
Well, I'd say, unfortunately, I mean, Becky, Brian, and myself are not, you know, official members of the campaigns committee, so I'm not certain what communications have been made. I know that the you know, the folks running the campaign are taking, you know, efforts now to raise and counter the funding that's available. But I don't think any amount of donation, absent, you know, a wealthy individual putting up most of their money, is going to get us to the $181 million point. I think part of it is the messaging, the work we're organizing, and really cutting through some of the noise, which is what we would attempt to do. Because again, if money were the only issue, you know, we know there would be a lot of different outcomes on some of these issues. So I don't think it's only about the money.
No, California only has $12 million. If this was a gubernatorial, I have difficulty saying the word, let's say a presidential race, and somebody only had 12 million to 180 million, that would guarantee the $12 million candidate would lose. So I'm not saying we need as much money, but if we had a quarter that we could do something with, that we could advertise and get our message out, we stand a chance of winning. But we're going to do what we can anyway. You know, we're going to do the phone banks and all that stuff. But we can't be complacent, you know, because I feel that because the average voter was complacent, that's how come we got Trump. You know, we need money. And to pretend that we don't, it seems foolish to me.
I think you're right.
But I think, you know, we've had so much in the way of workers' actions and workers telling their own stories out there. I think that has been really helpful. And I think the more we get endorsements and get organizations that are identified with progressive causes on board, that also really helps. We know that We've got Joe Biden, who has said, please vote no. We are hearing that I've heard that the Democrats are doing the same thing in California. And so it seems to me that that's part of the way that we beat them. We center workers. We let people know they're spending $181 million. And for a lot of people, I think that's a turnoff. And then we be sure that people who have influence are hearing about what this proposition is and are getting activated. And I'm seeing that we're almost at time. I just want to thank everyone for being part of this webinar, for listening to us, for sharing your thoughts and your comments and your interests. If there's any last words from Ray or Brian, please jump in, or any last burning question.
Thank you all for joining.
Thank you so much. We really appreciate it.
Thank you all. We'll be in touch.